Hey folks, welcome back to the Edupedia world, and I am Abhinay Gupta. And today again we are going to continue with the interpretation of statutes, deeds and documents. Right? So we have already had a couple of lectures on this and we have covered most of the rules so far, right? But in the immediate preceding lecture we were discussing about the rule of exceptional construction. Right? And due to the scarcity of time we could not complete with the entire rule, and we still have two minute portions, right, the end of this rule that we need to discuss. And today we'll also discuss a question that have been asked in your previous examination, right? Otherwise, as I've already told you, that you always get a direct question on this rule, right? Like most of the times there's one indirect question that has been asked and I'll be discussing it with you in the class today, right? But that provision, that question was asked in, I guess, 2013, right? And those provisions are no more applicable for you because that was in the Companies Act 1956 and depended upon the sole selling agent, right? You don't have that concept again over here in 2013, right? So let's start with that. We'll discuss with it again, and if someone of you who have missed out the previous lecture, please go back, otherwise you will not be able to follow with this lecture, right? Because this is just a continuation of the previous lecture. Okay, so we continue with it. The rule of exceptional construction. So in the previous lecture we have already seen the common sense rule, right, that you need to eliminate the word with senseless meanings. Then we have also seen the interpretation of and, or, right, the two words. That and is normally conjunctive, that they join the two provisions, this and this both are applicable, and or either this or that is applicable. When it is and, fulfills the requirement of both the provision. When it is or, you need to fulfill the requirement of any one of the provision. Then we are also seen the interpretation of the word may, which is generally which generally has the directive force, but exceptionally it may also have the mandatory force bestowed upon it, right? And then we have seen the interpretation of shall, which generally has the mandatory force, mandatory effect, but exceptionally can also have directory effects at times. And we have seen the cases, right, in case of both may and shall, where we have seen the opposite, right? The exceptional situations have been discussed. So if you have missed out on it, please go back in the previous lecture, you'll get it over there. We have discussed it in detail already, right with it. So should we start with the lecture of the day? Today we move ahead with the same topic, the same rule, the rule of exceptional construction. But as I told you, we have already had a direct question which asked about the distinction between the mandatory and the directory rule, the force, right? What is the difference between mandatory and directory? What effect does it has? So now the next topic that we have, since in the interpretation of may and the interpretation of shall, we've already seen that there are two situations. Generally it's directory, exceptionally mandatory, or opposite, generally mandatory, exceptionally directory. So what is the meaning of this directory and mandatory that we are using over here, right? We are using it very widely in this rule. So what does that mean actually? What do we interpret, what do we construe out of it, right? So basically there are two categories in which we can evaluate both the forces, right? So first is the compliance requirement. So if it is directory, right, then the provision, the statute, the legislature, they give you an option, right? They give you a direction that okay, even this option is available for you. If you want, you can go ahead with that. If you don't want, we are okay with it. That is directory. They're directing you, they're guiding you. And mandatory is they're forcing you. Hey, turn right and please start walking. That is the direction you need to follow. That is a mandatory force, right? One is opening a door for you. If you want, you may cross. If you don't want, don't. And the other is opening a door and kicking you inside it, right? They're just pushing you through that you have to cross the door, right? Now if we consider it in the terms of law, terms of the statute, then we would say that when we talk about the mandatory provision, right, it has certain substantive procedures, right, substantive conditions, right, which is in hand and you can see it, you can abide by it, you can follow it, those type of conditions you have, and it becomes mandatory for you that you have to strictly abide by it. That provision has to be strictly observed, right? Whereas directory is somewhat technical. Okay, we are giving an option, even this can be done. For example, if you are again filing the e-return, right? That is directory, that you can also file the e-return, but that is not mandatory, right? Even substantial compliance in that field towards that direction will suffice the need, right? We ask you to prepare documents like this. It is directory. For example, you may prepare additionally these documents. So even if you prepare one or two of those, that is enough. You don't have to prepare. If there are 10 documents that have been asked to prepare, you do not have to prepare all the 10. But if it is mandatory, then you have to prepare all the 10, and that is to be prepared according to how you have been instructed, right? So this is basically what matters when you talk about the mandatory force and the directory force, right? One is substantial condition and the other is a technical condition. In the mandatory, it has to be strictly observed, whereas in directory, you may not. Even substantial compliance, that means if you comply with it to some extent also, right? It is okay with them. There's no problem over there, right? That is the meaning of the compliance thing over there, right? But yeah, directory provision, the substantial compliance will suffice unless it results in the loss of prejudice to the other party, right? But if it is hampering, or if it results in the loss to the other party, then you cannot go ahead with it. That is strictly not allowed. Getting the point? Understanding it? Good to go. So that is about the compliance, right? Next, what is the consequence if you do not do it? It is mandatory, you have to do it. But what if you don't? It is directory, you have to do it. What if you don't? So if it is directory and you do not do it, right, you won't succumb to any penalty kind of a thing, because that was the direction they were trying to give it to you. If you want, you take it. If you don't want, you don't take it, right? It does not have any repercussion behind. But if it is mandatory and they say that you have to do it and you don't do it, then you are liable to certain punishments. So for this, the act says, or the statute says, that the lapse of mandatory provision cannot be condoned, right? You cannot excuse it. If you do not abide by any mandatory provision, you have to bear the repercussions, right? So they say it must be obeyed in letter and in spirit, right? That means in document also, if we say it has to be done, you have to do it like that, and in spirit also, that you have to take it, that yes, I am doing it. It is a mandatory force, and that has to be observed always. And if you're not observing it, right, punishment is a separate thing, but the act that you have done also becomes invalid. It does not mean that, okay, you bear the consequences and you go ahead with it. No, you will bear the consequences, and what you have done will also be termed as invalid. So it will have no effect at the end of the day. Plus you are bearing the consequences, so what is the point, right? So if the act or the statute says that yeah, this is mandatory and you have to follow it accordingly, please go ahead with it. Otherwise you're not gaining anything out of it. Whatever you're doing is a waste. Why? Because that will be invalid. Plus you may also be succumbed to certain penalties, certain punishments for that, right? And on the other hand, if something is directory, right, then you should be following it. Why? Because if it is directory, the reason behind it is that it is important. That is why the legislature or the legislature thought that yeah, they have to bring out a statute directing you that yeah, this can be done, this will help you. So it is better for you that you do it. But even if you do not do it, right, or even if you fail to do it, that does not cause any repercussion behind, right? The lapse in that compliance is not viewed very seriously, right, in order to go ahead and punish you. Okay? And one more important thing is that if you're not doing it, that does not mean that the act is invalid. The act always remains valid in case of directory provision, but it becomes invalid in case of mandatory provision if that provision is not followed, or if the provision is not abided by, right? Bear the repercussion, plus the act is invalid. Over here you may not have a repercussion, but the act always remains valid, right? So that is the basic difference between the mandatory and the directory force. If it comes in the examination, you bifurcate it into two and say that okay, in terms of compliance this is a difference, and in terms of your consequence this is a difference, right? Next we have how to judge, right? We talked about it that yeah, you need to judge whether it is mandatory, whether it is directory, how to go about with it. But the point is, how do you judge whether it is mandatory or directory? If it is a statute, something is written in it, how do you interpret it, right? So let us see what are the factors behind it, right? So it's here on the screen. So first understand one thing, right? There cannot be laid a general rule that you can just follow and decide whether it is mandatory or directory. You cannot, because if it was that simple, then the legislature would have pinpointed everywhere that okay, this is mandatory, this is directory, and this is the consequence, that would have been included in the statute, right? Just because it is not so simple and it would require interpretation at times, right? Depending upon the situation, depending upon a lot of things. So it is given upon your discretion that yes, you decide whether it is directory and mandatory and then go ahead with it as you want to, right? So for that, basically, first of all, what you see, if we consider the factors, then it is the nature and design of the statute. So you see, why is the statute created? What is the nature of the statute? Is it created to direct you with something, that how is something to be applied, or is it created with some specific task that yes, this has to be followed, right? You have to understand the nature, you have to understand the design. How is it formulated? Is it including the penalties and other things also, or is it just giving you some information as to go about with it? If it is information, it is directory. If it also includes mandatory force and punishment and other things, it is mandatory, right? That is what you need to judge by the nature and the design of the statute. Okay with it? Following it, you also need to judge the real intention of the legislature. What does it want, right? So if it is a specific field and they have said that this is to be done, then you understand what is their intention, whether they want it to be done always, or whether they're trying to help you out with, okay, you can do this and that will be better for you. What is the intention, right? If they want it to be done anyhow, then that is mandatory. But if they give you an option and they're giving you a direction that, okay, for better presentation you can do this, if they say for better presentation, that means, okay, if I don't want a better presentation, I will avoid it. So that is the intention of the statute, right? You have to take it under consideration before deciding whether something is mandatory or directory, right? Then you see the consequence. So when we talk about the consequences, then there are two types of consequences that we're talking about. One consequence is the result that you gain out of the statute. That means if you are abiding by it or not abiding by it, what would it lead to, right? If we are talking about presentation of the financial statement, then the better presentation, what will it lead to? Or the same presentation, what will it lead to? That is the consequence. And the other consequence is the reaction that you get if you are not, or you are following it, right? That means if you are not complying with a provision, right, whether the consequence is trivial or whether it is serious, or whether it is serious, yeah, you have to see that, right? Whether you are punished for it or whether you are let loose for it. Those are the kinds of consequences you have to consider. So in both the situations, right, if your work is not done, if that is facing a little difficulty, then you may say that, okay, if without this my work cannot be done, that means it is mandatory, right? So they have said you do this because without it the work cannot be done. But if they say you do this, it would be a better presentation, it would give you a better edge upon the rest, then okay, I can avoid it. If I don't want a better edge, then what? Understand the point? That is one consequence. And other is, are there any penalties following? If there are penalties following, it is mandatory. If there are no penalties following, it is directory. That is what you judge, right? And after that, the last one is the impact of other provisions. Now the other provisions that we are talking over here are those provisions to which we can resort instead of complying with the provision that is given in the statute. So the statute says you have to do this, and we say, okay, apart from this, if we go this, then we fulfill both the situation and we will not have to follow the statute. So if you think that the other will be able to fulfill your task very well, then that is directory. Okay, you may do this, you may not do this, do that, we are okay with it. But if that is not fulfilling your task, if that is not being able to achieve the objective, right, then what you do? Then in that case, you know that, okay, this is the only way out, and then you consider it to be mandatory. Okay with it? Clear? So ultimately, what do we understand out of it? That if something is prohibitory, right, that means if they say they inculcate a negative word, right, saying that no, this provision is mandatory. If you are prohibited from doing something, if you're prohibited from some act, that means you cannot do it, right? It is prohibited. So that is not a direction that, okay, we don't want you to do it, but if you want, you can do it. No, it is prohibited. That means you will not do it. That is mandatory for you, right? And other that we have already discussed, that if the non-compliance results in penalty, that means it has to be done. Why will you bear the penalty otherwise, right? If it is directory, if it's an option, then why penalty? Penalty is because it is mandatory, you have to do it. If you are not doing it, bear the penalty, right? And if, that we have already discussed, if the provision gives you a power coupled with the duty, it becomes mandatory. It has given you a power that yeah, you can do this, but it is again your duty to do it. So it is mandatory that you have to use your power over there. It's a power that does not mean it's discretionary, whether you use it or whether you do not use it, right? But if the power is given and then you have the duty to apply that power, then the power becomes mandatory force for you, right? Now, if there is some public policy involved, right, then it becomes mandatory. Why? Because the public is involved. You have to do it for the public. And if it is not involved, it becomes directory. But okay, we are not involving any public policy that is general for the public. It is not involved. This is something separately we are giving it to you. Do it, don't do it, we don't care a lot. That will not impact the public policy, right? And now, if there is any provision that has been enacted to avoid some mischief or to advance a remedy that we have discussed already, right, to prevent a fraud, to prevent a mischief, or to advance a remedy, then it becomes mandatory. That if you do not do it, then those mischief will occur, right? Those frauds will take place. So we don't want that fraud, right? So for that case, you will have to apply these provisions. Okay with it? And finally, we have to give due consideration to the object of the statute. And if non-compliance is defeating the object, then dude, it is mandatory for you. There's nothing out of it, right? So what did you see? How did you judge it, right? Basically, you have the factors, the nature and the design of statute, the intention of the legislature, the consequences, both ways, either you are giving the penalty or your work is not done, and the impact of the other provision that could have substituted it, right? If it can substitute it, the impact is good, go ahead with it, it is directory. But if it cannot substitute and you have to follow this, then it becomes mandatory, right? So that was all about the rule of exceptional construction. Big rule, I understand. Lot of things in it, again I understand. But even you have been asked questions in the past 4 to 5 times from this particular rule. So we could not avoid it, right? And it is not very difficult if you understand. There are 3-4 things you need to know. Difference between mandatory and directory, may, shall, and or. That's it. And understand that you will not get a question where you have to analyze using all the factors that we have seen. That analyze and say whether it is mandatory or directory. No, you will not get such kind of questions. What questions you get generally in the examination from this kind of rules is that, okay, this is a situation. Is it mandatory? Is it directory? And you know, right? You do not have to say that we have checked this, we have checked that. No, you automatically understand it is mandatory or it is directory. And then you have to give what is given in the text. How do you see? What are the factors? Oh, nature, intention, consequence, impact. Right? That is what you have to give, and you are okay with it. Nothing else. Right? So for that, to give you a proper demonstration of that, I have a question. Right? But as I told you, this question is not from your Companies Act 2013. It belongs to your Companies Act 1956, because it was even asked in CA Final 2013. Specifically May 2013, right? So the question is already on the screen. Please read it. So it says, section 294(2), the sole selling agent, right? You remember there was a 2-page, 3-page chapter in your previous syllabus. If anybody has also gone through the previous syllabus, if all of you are just new students with Companies Act 2013, right, then you have never heard about the concept, and I don't think you will. In your syllabus for final exam, you do not have this concept of sole selling agent. Right? But earlier, I'll give you a background, right? There was a sole selling agent, section 294 of Companies Act 1956. What was a sole selling agent? That in a particular area, geographical area or a particular market, what you used to do is that you used to appoint an agent. And that was a sole selling agent. That means that would be only one agent of your company over there. That is the priority he's getting. That he is the only seller. Now he'll buy all the products from you and distribute it in that area. Right? Then the board of directors, they used to appoint the sole selling agent, and he was supposed to be, the appointment was supposed to be ratified in the subsequent general meeting. Otherwise it would be a flop. Right? He would be dismissed. So it's a big priority. So there was bribing and all sort of things that was going on, right? Because sole selling agent is a big distributor, man. Right? So you understand? Now what it says over here, Section 294 subsection 2 of the Companies Act 1956 provides that board shall not appoint a sole selling agent for any area except subject to the conditions that appointment shall be caused to be valid if it is not approved in the companies in the first general meeting. So the directors could appoint him, but the appointment would be ceased to be valid. That means it would become invalid if the board did not, if the general meeting members did not approve it. Right? In the general meeting held after the date on which the appointment was made. And the question says, examine whether the procedure under the above provision is mandatory or directory. So what do you think? Is it directory? Understand one simple thing, right? Who has the power to appoint the sole selling agent? Who had basically? It was the board of directors, right? But sole selling agent, right, it is a very important post. People may give bribe for it. They're okay, a director, come here. Under the table, take rupees 1 lakh, give me the position. The director would again use his skill in his board meeting, pass a resolution and just say, okay, he's a sole selling agent, right? So to avoid that biasness, right, that is behind the scene, right? That is why the legislature, they brought out a statute that it has to be approved by the members in the general meeting, otherwise it would be void. So what do you think? Is it directory? Is it mandatory? Do you think you need to apply the provisions that you have read? No. You straight away understand it is a mandatory thing. It is not an option that, okay, if you want, please take resolution. Why do you need to take a resolution at all? It is not something that the board of directors will not understand and they are waiting for the members to come and explain it to them, or how is it happening. It is not something that would improve the situation, right? The board have already appointed him, but that power of the board is checked by the shareholders. That is why it becomes mandatory. If it was something to help the board of directors to decide because they are not able to understand, that they are not able to decide, then we would say, okay, it is a directory thing. Like if we would say that if you don't understand, please include an expert. It would be a direction. If you understand, go with it. If you don't understand, include an expert. But over here, your powers are being checked. And that is why they say that the shareholders will have to ratify it. Understand? So it is mandatory. So what do you write? You will not write any of such interpretation that I have given you. Why? Because you do not know what is the exact interpretation. So why do you try to risk your answer? Just say that yes, it is mandatory. And then give out the consequences, that yes, if they are not doing it, we see the consequence, right? Because if they do not ratify it, if the members do not ratify it, it becomes void. So if it is void, that means it's a big consequence. On the basis of the consequence, you are deciding that okay, it is mandatory. Yeah, so just say that because the consequence that is following would make it void ab initio, hence it is considered to be a mandatory provision. And moreover, if at that point of time you did not include a condition that your appointment is subject to the approval of the members in the general meeting, then his appointment would become void ab initio. Even though later on in the general meeting the members ratify it, they say okay, we are okay with him, but still his appointment would be void. Why? Because his appointment basically has a mandatory condition that his appointment is not valid unless and until it is ratified by the members in the board meeting. Clear with that? So if the Act says that you have such a provision, that means you have such a provision. You always have to include that condition in his appointment. Right? Then they say, examine whether the procedure under the above provision is mandatory or directory. So this is not just what you're going to write in your answer. Right? Next, you automatically go on to include, because they also say that you have to also state the distinction between the mandatory and the directory provision. But even if they don't write, include it. Why? Because they are asking you to compare and you have not given anything substantial so far. So it is better you include such comparison so that they know that yes, you know the answer and you have given it on the basis of such assessment. Right? So you say that okay, the mandatory provision prescribes substantive condition, whereas directive they give you technical conditions. Mandatory has to be strictly observed, directory may not be observed. Right? If you do not observe mandatory, there are penalties following. Right? And the lapse of mandatory provision cannot be condoned. It must be obeyed in the letter and spirit. These are the terms that you have studied, right? I have already taught you. So you have to use these words, these sentences, and then frame your answer beautifully, and you get all the marks over there. Right? So that is all about the law or the rule of exceptional construction. And I hope that is clear with you. Always remember, there are few questions only that is being formed from this rule, and or right, conjunctive and the stuff that we have said, that two provisions have to follow both, or two provisions any one. These things have to be explained, right? Or the distinction between may, shall, or maybe may. If it is directory, then in what situations are those considered to be mandatory? Shall, if it is mandatory, then in which situation, which are the exceptional situations when it will be considered to be directory? These are the kinds of questions that are being asked in the examination. Distinction between mandatory and directory, and one question of this sort that I have shown you. Right? So before leaving the class today, right, I would again revise the concept or the exceptions in the may and shall, right, so that you remember it. Okay with it? You're there with me? So which are the situations when may is considered to be a mandatory force? Number one, where it is the subject involves a direction coupled with an obligation. One, right? Number two, where you need to advance the remedy or suppress the mischief. Right? Number three, where may has been used as a matter of pure conventional courtesy. High authority people, right? Delegates, you do not say you shall do it, you say you may do it, but which means that yeah, you have to do it man, come on. And the last one was where giving it a directory force would defeat the object of the act or the statute, right? Or it may cause material danger to the public, right? Or it would result into the denial of benefit to the public. In those cases, may would be considered to be a mandatory force, right? And when will shall be considered to be a directory force? Again, for that we had three cases. One, if it is used against the government, then you cannot say that the government you have to do it. No, you may do it, man, come on, because government is the ultimate power, right? Otherwise, where the intention of the legislature demands it to be directory, then it will become directory, right? And the last is where giving it a mandatory force would result in an absurd result. So in that case, you will again consider it to be directory. So why did I revise it? Basically because I get questions on them, and I want you to know it, and I don't want you to lose any marks in this chapter as well, right? Prepare your law very well. When I'm there with you, I'll be discussing all the topics in detail slowly, and we'll go with the discussion of what are the kind of questions asked. After the end of the entire syllabus, I'll cover your practice manual as well, right? So even while you're going off and on from your office to and fro your job, your articleship, you can complete your entire syllabus on the way, right? If you have access to my videos now, you may have access to my videos anywhere, right? So with that, I assure you I'll take you ahead with the entire syllabus in the same way, and that will help you out with the examination. And if you have any query, if you have any suggestion to be made, please use the comment box below. I've always told that, right? I'll be there, I'll be replying you over there, and we'll stay connected. Okay? So with that, we come to the end of this class today, right? We have discussed the questions, we have discussed everything. Stay tuned for the next lecture that is coming up, the rule of aegisdem generis. Remember, now we are getting to that complicated name, right? So the next few classes are going to be very interesting. Stay tuned, and for the meantime, this is Abhinay Gupta signing off. Thank you and bye bye.